Welcome to the final spring 2026 session of the Insurance Law Workshop. Thank you for joining us. We're very happy to be hosting Alex Lemann, who's an associate professor at Marquette University Law School, and he'll be sharing his work on lessons from the first autonomous vehicle trial. Um, we'll be sending out, before we start, we'll be sending out the fall lineup within the next month or so. But if you'd like, you can just continue to hold this time on your schedule for the fall semester. We'll stay at this time, and so that might help you prevent accidentally double booking and not being able to attend. So with that, I'll hand it over to Alex.
Well, thank you, Travis. It's great to be here, and I've regretted very much that I haven't been able to attend most of the meetings this semester because of my teaching schedule, but I'm glad to be presenting now, and I want to thank you for the invitation to do this. So my presentation is about the first trial involving autonomous vehicle technology, which wrapped up just this past summer. Um, just some quick background on the project. It's an invited contribution to an edited volume called the Research Handbook on Products Liability Law, and the target for my sort of written piece is about 7,000 to 9,000 words, so shorter than your typical law review article. A quick overview of today's presentation. I'm going to start with an introduction to the case and then kind of some technological and factual background of events leading up to the crash. Oops. Then key facts from the trial, some themes and the outcome, prospects for appeal, subsequent developments, and then implications for insurance. So basic overview of the case in case some of you have not heard about this. The driver of Tesla named George McGee was driving with a technology that Tesla calls Autopilot engaged on a surface street in the Florida Keys and ran a stop sign at a T intersection and crashed into a Chevy Tahoe that was parked on the far side of the intersection. When he crashed into the Tahoe, he killed a woman named Benavides Leon, who was standing outside the car, and seriously injured her boyfriend, Dylan Angulo. The case led to a trial in federal court that took 15 days, and the jury returned a verdict for the plaintiffs. They found the driver, McGee, 67% responsible and Tesla 33% responsible. But even with that comparative fault finding, the result was a judgment against Tesla of $42 million in compensatory damages and $200 million in punitive damages. So some background on the technology involved. I won't delve into this in great detail, but some key terminology is the 5 levels of automation that the NHTSA came up with maybe about a decade ago now. And so the system that's involved in this case, Autopilot, is a level 2 automation system, despite its name, and the name was sort of a key focus at trial. So in a level 2 system, the car can handle certain aspects of driving, but it needs constant supervision from an attentive human driver. And so that's why the human is shown in this image, kind of holding the steering wheel and ideally, although you can't see their eyes, facing towards the road. This is in contrast to what we think of as highly autonomous vehicles or level 4 and 5 vehicles, where the human doesn't need to be paying attention, and indeed, sometimes there isn't even a human at all. So unfortunately, this is not Tesla's first fatality, and so there have been sort of a string of previous crashes leading up to this crash. The jury was told about some of these, and I think it's important background for understanding the case. So the first one is a crash that killed someone named Joshua Brown in 2016, also in Florida. This was widely reported in the media as the sort of first crash involving an autonomous vehicle. It was a head-on collision with a tractor trailer where the tractor trailer was clearly visible on the road for about 10 seconds before impact, but the driver did not react, neither braking nor steering in any way, suggesting that they just weren't watching the road. So this crash and the subsequent ones that I'll talk about raised 2 important themes for the Benavides case. The first one is the theme of driver inattention, and the second is the theme of operational design domain. So on the theme of driver inattention, This is an image from the NTSB's report on this crash. And you can see the gray in the bar showing when autopilot was engaged, and the vertical dashed green lines, which are almost invisible in this image, are showing when the driver had his hands on the steering wheel in the moments leading up to the crash. And you can sort of see from the yellow bars that he only puts his hands on the steering wheel when he gets a alert or a warning from Tesla, put your hands on the steering wheel or we will disengage. The upshot of all this is that in the 37 minutes leading up to the crash, he had his hands on the wheel for 25 seconds total. Okay, second important theme is what they call operational design domain. And so this refers to the sort of functional setting in which the autopilot system is designed to operate effectively. And so what Tesla will tell you, and I'll show you this language later, is that it's only designed to be used on a divided limited access highway. So that means what we normally think of as kind of a freeway or an interstate. So no crossing traffic, all traffic entering and exiting in the same direction. But you can see from this satellite image that the crash happened on a highway where there's high speed limits, but cars can turn in a perpendicular way, can enter perpendicular, and the technology is not designed to be able to handle that situation. Okay, next important crash is a crash that happened in California and killed someone named Walter Wang, who was an Apple engineer on his way to work when his car crashed into a concrete barrier on the highway. Once again, driver inattention is a big theme with this crash. This is a similar image from another NTSB report showing when he had his hands on the wheel and off the wheel in the moments leading up to the crash. The NTSB found that he was playing a world-building strategy game on his phone while he was driving to work, and that's why he wasn't paying attention as his car swerved off the road and crashed into this concrete barrier. Here you can see the place where the impact occurred. And so this crash, unlike the others, it doesn't implicate the problem of operational design domain because he's on a freeway. So far, so good. But the red arrows here are pointing to a bright lane line marking the exit ramp as compared with the faded lane line marking his lane. And so when the Tesla sees this, it thinks that his lane is continuing off to the left there and leads him straight into the barrier that you can sort of see in the distance between the exit and the highway. Okay, final crash is one that killed Jeremy Banner in 2019. The circumstances here eerily similar to the Joshua Brown crash from 3 years earlier. So it's also in Florida and also involved a Tesla crashing straight into a tractor trailer that had turned across its path. Once again, the driver was not paying attention to the road. This is footage from the actual car's vision system. So this is what the car was seeing as it approached the tractor trailer, and you can see that it's plainly visible if you're watching the road, but he doesn't react at all. The problem of operational design domain present here as well. It's a highway where you have perpendicular traffic and the system is really not designed to be able to handle that. Okay, so meanwhile, sort of
Can
against the
I,
backdrop,
Alex, do you have a sec
yeah,
for just a quick question about
mhm,
the operational design domain? Would,
yeah.
would it have been feasible to design the autopilot in a way that it knew what its design domain was and could say, well, I can't work because it's not the kind of domain that I'm designed for, or is that just not something that it can do?
It is feasible, yes. So there are a number of manufacturers who have level 2 systems like Tesla's. I want to say 13, and of those, only one, which is the Cadillac Super Cruise, has a geofence, built-in geofencing, so that you cannot activate it unless you're on the right type of highway. And so this was something that the parties kind of grappled with each other about at trial, right? From the plaintiff's perspective, the fact that Cadillac is doing this proves that it's technologically feasible. From the defense perspective, the overwhelming majority of manufacturers who have the same type of system as Tesla do not have any kind of operational design domain programmed into the system. So it's a point of contention. Yeah. Okay, so against this backdrop, Elon Musk is, this won't surprise anyone to hear, saying all sorts of crazy things about the capabilities of Tesla's autopilot system. There's endless numbers of quotes I could show you, but this is the most notorious incident, this tweet is introducing a video that's linked in the link there that is called the painted black video. And so he says in the tweet that Tesla is driving itself with no human input at all, and it can handle urban streets, highways, and then finding a parking spot in a parking lot. And this is from 2016. So he's showing that the autopilot can handle situations beyond what the user manual tells users to use. This is the kind of like opening image of the video that's linked. It's referred to as the painted black video because the Rolling Stones song Painted Black is playing as like the soundtrack of the video. And it says the person in the driver's seat's only there for legal reasons. He's not doing anything. The car is driving itself. And then I have the video, which I'm not going to show just for time reasons, but it's hard to find. The Tesla has since removed it from its website and tried to scrape every trace of it off the internet. The reason it's so hard to find is that it was revealed several years later to have been staged. This was revealed in a deposition from one of the engineers who worked on this project. And when I say staged, what I mean is they programmed the car to drive this very particular route. And so it's more like a child driving a remote control car and not like an autonomous vehicle, responding to its environment in real time. And in fact, the car crashed several times during the filming of the video. But of course, they edit that out. Okay, so pretrial proceedings in the Benavides case. There was a lot of motion practice, Daubert and summary judgment motions. Judge Bloom largely rejected Tesla's arguments in a 70-page opinion, quite thorough opinion, which set up the trial. The key theme for the trial from the plaintiff's side, this is the opening sentence of the plaintiff's opening arguments. We're here because Benavides and Angulo were made part of a beta test that they never signed up for. So the plaintiffs did a very clever job, I think, of acknowledging the negligence of the driver in this case, but presenting their clients, the plaintiffs, as innocent victims who did not choose to expose themselves to this danger in any way. And then they emphasized the history of crashes from Tesla that I've just talked about, the brash statements from Musk, and the investigations by the NTSB, where the NTSB is constantly saying, here's these issues that you need to address, and then Tesla never addresses them. From the defense side, they really leaned on the negligence of the driver, and with good reason. I mean, I have not yet fully divulged all the bad facts in terms of the driver's negligence, but we'll get into that in a minute. They emphasize for the jury the various disclaimers and warnings that you have to click through when you turn on autopilot in your car, and portray the Tesla technology as cutting edge and very much in line with industry standards, as I was just sort of alluding to in my response to Peter's question. Okay, so on the theme of driver distraction, this is the route that the driver took from his work to his home on the sort of evening in question. If any of you know the Miami area, which I don't very well, you'll recognize this as an exceedingly long commute. He's driving from Boca Raton to Key Largo. It's around 100 miles. And so a several-hour drive that he did several times a week. And he said that the part of the reason he bought this car and bought the autopilot system was to make this drive less burdensome. Meanwhile, in the 3 months that he owned the car leading up to the crash, has already sort of established a pattern of distracted driving for himself. So by the time in 2019 that this crash happened, Tesla has started to make incremental progress to addressing the problem of driver distraction. And the system that they put in place was called a strikeout, where if you don't have your hands on the steering wheel and you get enough warnings from the system, it will say you struck out and you cannot use autopilot anymore for the remainder of the drive cycle. But what that means is you can pull over, put the car in park, and then put it in drive again, and you're good to go. So McGee, the driver, did this a lot. In the 3 months that he owned the car, he had 23 strikeouts, many of them less than 10 minutes apart. And on the drive leading up to the crash, he had already had 1 strikeout and 5 warnings, and he was 1 chime away from another strikeout when he crashed into the victims. And one of the main theories that the plaintiffs had and the plaintiffs' experts talked about at trial was the idea that if the strikeout period had been a length of time, like a week, rather than just putting the car in park and starting it again, then that would have changed McGee's behavior. So McGee acknowledged at trial, and the defendants really leaned on this, that he was distracted. He was on the phone with American Airlines, trying to make arrangements for a flight across the country the following day, and he dropped his phone and was like looking around and reaching with one hand, trying to find his phone on the floor of his car when he ran through the stop sign. Meanwhile, so this is data from the car's recording system, and what the top kind of bar there is showing is the vehicle speed. So the speed limit on the road that he was driving on was 45, and that's the flat part of the line. But in the moments before the crash, he puts his foot on the accelerator and speeds up to above 60, so 62 miles per hour. So you can see that from the blue line in the middle bar there, that he's got about 20% depression on the accelerator pedal. And from the red line, you can see no braking at all. Meanwhile, he does appear to have at least one hand on the steering wheel, because this sort of magenta line is showing torque on the steering wheel. And that's the way the car measures the fact that he's paying attention, which, is only a proxy for attention, as this case shows. The problem of operational design domain implicated here as well. This is a surface street, not a highway. And as you can see, it's a T intersection where the road just ends and you cannot go straight. So interestingly, the Tesla recognizes that there is a stop sign. So this is the sort of data feed from its system. You can see it's correctly identified the stop sign. It's identified the white bar in the road where you're supposed to come to a stop at the stop sign. And it has identified that there's a flashing red light hanging above the intersection so that people don't blow through the intersection in this way. This is the same view, but advanced by a few, maybe even less than a second. And here you can see it's correctly identified that there's a car parked on the far side of those warning signs. And that's the car that the two victims were standing next to. So from the defense side, the emphasis was really on Tesla's system being state of the art. And so the defense experts tried with various other competing models of cars that were available at the time to replicate the circumstances of this crash. And what they found was that none of the cars tested could appropriately respond to a car parked perpendicularly across their travel lane. And that's because the systems that are involved are designed for a situation where you're on the highway and there's a car that slows down to a stop in front of you and you don't notice. And so it can detect traffic moving in front of it in a different way from just an object blocking the path. So this was part of Tesla's main argument. Another theme they leaned on is the warnings. And
Alex, can I just ask
yeah,
you about that?
yeah,
So
yeah, yeah,
if that had been a wall instead of a car, like, I don't know, just go back to the previous slide.
yeah.
Uh, it looks like there's maybe water on the other side or something like that. So that
Well,
could have been like a
it's an
seawall or
inflatable
something.
car, I think. It's
Oh, I
a
see.
giant pillow that's supposed to be a car. And so this is how they do the test they start with the cars pressing against each other to measure sort of like distance zero, and then
Hmm.
they back up until they get to the distance where they want to begin the test. Would it have been able to detect a brick wall? So the sort of like forward collision warning and automatic emergency braking are two systems that are common in regular cars today, and they are not designed to be able to detect even a brick wall. So they would say, and this is why the NTSB, when they investigate these crashes, they say the system did not malfunction. And when people sort of hear that, they think like, okay, it wasn't Tesla's fault or something like that. But it means a very sort of limited technical thing, which is it's not designed to handle this type of situation. Now, the way the technology has developed, nowadays, they've moved on to a system called full self-driving, which can detect brick walls. There's a very amusing YouTube video that I was tempted to show a clip of that highlights the flaws of Tesla's approach to this problem, which is to rely on cameras as opposed to LiDAR. So, most highly autonomous vehicle systems are using these spinning lasers that shoot out, millions of lasers per second. and can see that it's bouncing off an object. And there's a famous YouTuber who's named Mark something. Anyway, he set up a wall where he painted an image of a road onto a wall like Wile E. Coyote does in Roadrunner. And he tricked the Tesla and it drove straight into the wall because it's relying on vision like our eyes. And the Tesla could not understand that that was not a road and that was instead was a wall. So, and he tried it with other cars and they all reacted fine. So it's a very amusing video that I recommend checking out if you're curious. Okay, so here's the warnings that you see when you try to turn on autopilot. It's a big block of fine text that I don't think you can really read, but it says things like auto steer is in beta, which we say to encourage a higher level of vigilance. Auto steer is a driver assistance feature and does not make your vehicle autonomous. Pay attention to the road. Be prepared to take over at any time. Auto steer is designed for use on highways that have a center divider, clear lane markings, and no cross traffic. So all stuff that if you actually followed it, you would not get in a crash like the one we're seeing. Okay, the jury basically did not, well, I was about to sort of make too sweeping a generalization. They were not willing to exonerate Tesla despite the enormous evidence of the driver's negligence. They found the driver 67% responsible for the crash and Tesla only 33% responsible. But still, given the pattern of behavior from Tesla, they imposed $200 million of punitive damages. Tesla has appealed, so the judgment is stayed pending appeal. They have a pretty strong argument. There's that the punitive damages award in particular is going to be maybe overturned. There's precedent from a Florida Court of Appeals from one of the previous crashes that I told you about, Banner versus Tesla, holding that there was not enough evidence on punitive damages to get to the jury. And it's the same company and the same type of crash. So it'll be interesting to see how that plays out. They're currently, before the 11th Circuit. Meanwhile, as soon as the verdict came out, they settled a whole flurry of other cases. So they're clearly trying to kind of make this problem go away. There's commentators out there predicting that there's going to be a wave of future litigation involving Tesla because of the lag between where the technology is and how many miles there have been with various forms of automation activated versus, the way the court system sort of processes these cases. So that's the point that's being made by a blogger in this image here, that there's a sort of enormous volume of automated driving that has not yet made its way through the court system. I'm not sure if that's fully true. Meanwhile, Tesla has discontinued the term autopilot finally, and now refers to its system as full self-driving supervised, which is sort of an oxymoron, and reflects some of the tension that goes on between safety and marketing at Tesla. Meanwhile, they've largely bet the company on the idea that they're going to achieve level 4 and 5 highly autonomous vehicles. They're currently manufacturing something called this cyber cab, which you can see on the left, that has no pedals or steering wheel at all. It's 2 seats, and it's meant to operate in autonomous ride-sharing service called robotaxi. That does currently exist, but only in a very, very limited way compared to competitors like Waymo. Meanwhile, there's indications that other manufacturers who have similar technology are going to be facing similar lawsuits. So Ford's Blue Cruise system is another one that is, virtually identical to Tesla's Autopilot, but without the crazy name. And it is starting to be implicated in fatal crashes as well. So some lessons and takeaways from all this. I think there's some sort of interesting implications for CGL insurers and car insurers. And then there's questions that we could get into about level 2 driver assistance systems versus level 4 and 5 highly autonomous vehicles. And then maybe implications for the civil justice system in an AI age generally. So before I sort of spin out these theories, maybe a note of caution. Benavides, it's just one case. I don't want to overread, one data point. There's an appeal pending, so it's possible that it'll get reversed in various ways. And there's some facts in what I told you that make it relatively unusual, if not maybe unique exactly. Okay, one implication of the case or sort of takeaway is that it could lead to expanded liability for what we would have previously thought of as like typical car crashes, expanded liability for car manufacturers and therefore maybe their liability insurers. So in this model, we sort of see a shift of the costs of car accidents up the chain from drivers and their car insurance companies to manufacturers and their liability insurers. Um, on one hand, some arguments that that might not happen. Tesla's pretty much, a uniquely bad outlier in the way that they kind of market this stuff to the world. And that's a big reason for the jury's giant punitive damages award. And I don't know that we're going to see stuff like that with other manufacturers. And, that possibly for that reason, they seem to be overrepresented in the fatal crashes that have happened so far. So it's possible that we might not see a wave of litigation like that blog post was predicting. On the other hand, as I've mentioned, Tesla's technology is really not meaningfully different from that of other level 2 driver assistance systems that are really widely represented in the market today. So if that's true, then we could be at the beginning of a significant problem. Okay, so from a sort of CGL perspective, if you're an insurer of a car manufacturer, there's kind of two sets of issues. The first one is the liability issues. So how likely is it that manufacturers will continue to be held liable for this stuff? This case to me suggests at least that plaintiffs will have some success in litigating this. So they had various theories of design defect, chiefly surrounding the issues that I talked about of driver engagement and operational design domain, and the idea that the system is defective because it doesn't account for human inability to pay attention to boring tasks like driving if there's nothing for the human to do. And that makes it arguably defective, even if it's not malfunctioning in the sense that it's encountering situations that it was not designed to be able to handle. So comparative fault is going to remain a big part of this, but in a state like Florida where there's no modified comparative fault, so no bar to recovery, you might still see judgments against car manufacturers, even if the jury thinks that the driver is mostly to blame for the accident. And then punitive damages, I don't know if other manufacturers will be exposed in the same way Tesla is. Then moving beyond the liability issues, we have coverage problems. Obviously punitive damages are often excluded, so maybe a liability insurer won't have to worry about that. I think another kind of lurking issue here is the possible application of an expected or intended harm exclusion. I think probably some of you know more about this than I do, but I've been a little bit surprised in recent years by courts' willingness to apply this exclusion to sort of products liability kind of design defect issues, including there is an opinion in Delaware applying California law holding that Meta, Facebook, did not have coverage for the liability in the social media addiction cases because the sort of design choices that they made in setting up their algorithm were intended. And even though they didn't intend to hurt teenagers, they are taking a series of intentional choices about how to set up their algorithm that result in harm. Similar results in some of the opioid coverage cases where courts say that if you're running a pharmacy and you make choices to sort of over dispense opioids, then you're not going to have coverage for the resulting liability. So that's an interesting issue. Shifting focus to car insurers. So there's a possible subrogation issue that I think is interesting. Could McGee's car insurer have pursued a subrogation claim against Tesla as another way of kind of shifting the costs of accidents up towards the manufacturer? I think they could have. You wonder whether it would be worth it for a car insurer, given the enormous complexity and cost of litigating a case like this. But I think it's possible that as the cases get decided, that it becomes easier for plaintiffs to prove them because they can rely more on some of the groundwork that earlier plaintiffs have done. Another kind of looming question here is how much is autonomous driving going to impact, the sort of bottom line of car insurers? There's some indications out there that car insurers view autonomous driving, even with just level 2 systems, as safer than human driving. And so this car insurer Lemonade got headlines recently by announcing that they would charge 50% less for miles that you drive while using Tesla's full self-driving, because their attitude is that it is safer than just human driving, which, as we know, has a lot of flaws. On the other hand, there's a lot of sort of debate about this. And so Tracy Pearl recently posted an article to SSRN that really delves into the behavioral science behind this and suggests that level 2 driver assistance systems are really not helpful, and in fact create more danger because they lull people into what they call automation complacency. So the sense that the car is handling driving and I can do things like pick up my cell phone from the ground because the car will handle it. There's a whole set of deeper questions lurking in the background here that that we law professors have been engaging with for many, many years now. And so there's a whole body of scholarship on, how does the civil justice system handle autonomous vehicles? And there's sort of a number, I don't know if it's fair to sort people into camps exactly, but there have been a range of viewpoints on this. And some people have said that civil justice system as it currently exists really can't handle autonomous driving because it involves things like AI and machine learning, and this will be impossible for judges and juries to really wrap their minds around or scrutinize in any meaningful way. And in my mind, this case is sort of a single data point in favor of the tort system as it currently exists, being able to sort of understand and handle these technological questions adequately. Now, the case doesn't involve a highly autonomous vehicle, so maybe that will prove more of a challenge, but we will see. With that, I wanted to close and turn it over to your thoughts and questions.
Well, thank you. That was great. Fascinating. So the queue is open to anyone who would like to ask a question. You can raise your hand using the little Zoom hand raise function, or
Should I let you call in people, or?
well, you should feel free to.
Okay. I don't see any hands right now, but I'll just hopefully I will have them visible to me. Let's see. Dan, yes.
Hi.
Hi.
Super interesting, Alex. I am just wondering about whether or not it's clear that Tesla or other companies actually have CGL coverage currently that would cover this, or whether CGL insurers are either reluctant to cover this, forget about the coverage issues, just issue a policy, or whether, my understanding is that Tesla as a company, given obviously the deep pockets of Elon Musk, oftentimes doesn't even buy insurance because they don't think it makes sense. So I was wondering if you have any information about sort of the current insurance coverage programs that Tesla in particular has, or other companies that are potentially exposed to this liability.
Yeah, it's a great question. It's something I've wondered about, and the short answer is I don't know. If you have any suggestions about how I could figure that out, I would love to hear them. I was shocked that Meta has liability insurance. In that
Yeah.
previous case, it would have struck me that they have plenty of money and they should just self-insure. So yeah, I don't know.
I mean, would assume that there's information about that in some of their securities filings.
Mm-hmm.
So I think that's one place I would look. I do think Tesla's at least made, or Elon Musk has at least made some statements about the fact that they don't need to buy insurance. I do think different companies have different, even very large companies have different attitudes towards this. I also just wonder, I actually also, on the Meta point, I am my understanding of that holding. And actually, by the way, Renee Henson sort of did a talk, I don't know, about a month or two ago that touched on this and has an article on this that might be worth checking out. But my understanding there was that part of the issue was the definition of an occurrence, right? And that there wasn't an occurrence because there actually wasn't an accident in a sense, right? And I think at least it'd be hard to say in one of these cases there's not an accident, right? We call it a car accident.
Yeah.
So I do wonder whether or not that issue, because I don't think the intended or expected acts exclusion would apply in and of itself, because it's pretty clear, I think, that there you need to have some particularity in the harm that you expect, as opposed to saying, well, we think like 0.01% of our cars will fail in an accident. Like that's not an expected or intended harm. So I do think it's usually more about the accident and occurrence language. And I just wonder whether it would play out differently. So I mean, I don't know. Actually, I haven't thought much about this, but I just think that's something else to think about. That's interesting.
Yeah, okay, that's really interesting. And I see what you're saying about the whole accident thing. And I just this morning had my final class in insurance using your casebook. And I was thinking about the case of William Winkler, who, set fire to a trash can in his school.
Right,
and,
right.
Yeah, so, but yes, so I see what you're saying. Like, it does seem like there must be an quote unquote accident here. Because there's a car accident. Yes, yeah. So I need to look into that more, and I think it's a really interesting question. Kathy.
Hi, Alex. Nice to see you. It's been
Good
a
to see you
long
too.
time. This is a fascinating topic. Couple thoughts. The first, I have to say, the most shocking thing you said that you were just discussing was this idea of how the expected or intended harm exclusion might apply. Because I'd be surprised if it applied like broadly, let's say to products liability. But of course, one of the other issues in the Meta case that's different from Tesla, where everyone's going to agree this is like a cyber product. In Meta, there's lots of fight about, is this a product? Is it a service? What is it? What kind of insurance would we need? Et cetera, et cetera. So that's just a comment. On the Benavides case, I remember reading, I can't remember, I think it was in some of the pre-trial stuff, but maybe it was also the jury verdict. It's too bad. I did this in a seminar, so don't divulge to my students. But in reading it, one of the things that was really fascinating and jumped out to me were the two experts that were involved. Like one of them looked like a traditional car reconstruction, and another person was framed as an AI expert. So I thought I wanted to ask your views on like, when we think about can the civil jury system handle this, part of the issue is what's an AI expert, or what kind of expertise do you need to help a court figure this stuff out? It seems very, very different potentially from just a traditional, accident reconstruction mechanical engineer. But my real question, the final one, is have you given any thought to whether there'll be liability directly against these insurance companies, particularly the ones offering premium discounts, et cetera? Not only like we'll give you a discount if you use a Tesla, but we'll give you a discount if you let us to monitor everything you're doing in the car, as some insurers are starting to do. And on that theory, people seem to look at that like, oh, that's great. They can, get data and they can lower your premium. Usually they promise people your premium won't go up. They could just go down when you show us you're such a good driver. But let's say they have a record that every time you're driving, you've got a lead foot, or every time you're, distracted, you're looking out the window or on your phone, and they have all this information and they never do anything about it. They don't alert, they don't stop your car. They don't have any guardrails. They just have this information. To me, it seems sort of natural. If I were a plaintiff's attorney, I would be framing a case directly against them for their knowledge and failure to act to mitigate these risks. I'm wondering your thoughts about that.
Yeah, okay, that's really interesting. So on the AI expert point, I wonder if the person that you're thinking about is this woman named Missy Cummings, who is a sort of famous figure in this area. She sounds like a fascinating person. She's a former Navy fighter pilot who lost a friend in a carrier landing and decided to go into like the field of kind of systems safety or something and became an MIT professor. And now she is the most outspoken critic of Elon Musk and Tesla's whole sort of approach to automation. And she was one of the experts in this case. And she really has built up an expertise around kind of like, I'm not going to get the technical term correct, but like human sort of automation systems interface or something like that, where the way that automation systems are designed to interact with human psychology creates these like foreseeable problems. And I agree with you that that's like a whole other level of expertise beyond what you would see in your typical car crash case. And there's only one of her, so how much of a role can she play in the future litigation about all this? Okay, it's an interesting point that you raise about what we used to call telematics devices that are these devices that insurance companies use to monitor driving. My understanding is that nowadays they just use an app on your smartphone because your smartphone has such sophisticated like gyroscopes inside of it that they don't need a special device to plug into your car anymore. I don't know if that has ever been tried. To me, it sort of sounds like a classic, like maybe a duty problem, depending on if I'm sort of putting on my torts professor hat. Like, now they do, I think, send a report to the policyholder, maybe on a monthly basis, where they say, like, here's what we like. It's like your report card, here's what we liked from what we saw of your driving over the past whatever time period. And here's some instances where we weren't so thrilled, sort of like room for improvement. Or so maybe that's enough for them to sort of argue that they are kind of trying to nudge the driver in the direction of safer driving. And some of them do even like play a sound if you brake too hard, like it'll buzz at you or something like that. But yeah, it's an interesting area, and I'm not aware that anybody has thought of that as an avenue of liability before.
Don't they charge you more when you're, I mean, I thought the whole point of the telematics was they could just like, well, you drove 3 miles at 90 miles an hour. So that means that you got to pay, 10 cents more or something like that.
Some of them promise that they will only reduce
I see.
and that's to get you to sign up. But I think some of them do increase your premiums if they really don't like what they see. And then, everyone, I wrote a paper about this many years ago, and everyone wanted to talk about the privacy implications. And so I, think probably that the car insurers would say we're walking a fine line here with people's willingness to kind of invite us into the car with them. And the more we try to micromanage their driving, the more the whole game will be up, and and they won't let us do this anymore. So who knows? Traver, I see your hand next.
Hi. So first, I just wanted to say thank you so much for doing this. This was absolutely fascinating. But anyways, my question was how much, and I guess this is somewhat of an opinion, but as someone who's never read the case, how much of this case was decided based off of the factor of just Elon Musk's boisterous and on top of the world attitude, and Tesla's, frankly, from especially the video you showed, they're very bad marketing versus Tesla actually being held at fault? Because if they were, I mean, from my bad understanding, the driver of that car was told multiple times, "Hey, you're taking your attention away from the vehicle." It would seem to me like the negligence would fall almost, especially in this level 2 scenario that you're describing, the negligence would fall on the driver. I mean, the car told them, "Hey, this is a new technology." I know the argument that the plaintiffs tried to make was, "Oh, well, we didn't sign up to be a beta tester." Well, they kind of did, though. I mean, it's a brand new state of the art technology. So was this exclusively due to Musk being, ridiculous with his marketing and Tesla being ridiculous? Because there's a lot of other manufacturers that have level 2 autonomous driving, but they don't, or they didn't call it autopilot per se.
Yeah. I mean, it's hard to know. It's hard to know. You raise a really interesting, important point, and it's hard to know, what did the jury sort of find persuasive as it's assessing these technically sort of legally distinct concepts of, defect versus punitive damages, things like that. I think you're right that a big part of this is using the name autopilot. And this is something that the NTSB has been, screaming about for many years. They criticize Tesla for calling it autopilot because it creates this misimpression in people's mind that it is an autopilot that you can just kind of like turn on and open up a book or something, which is very much, not how it works. And other companies don't use the term autopilot. They say things like, super cruise or blue cruise, and that does a much better job of conveying the idea to the customer that this is basically cruise control. It's like slightly better cruise control. So I do think that's a big part of it. There's some stuff in the jury instructions about, some of Elon's, statements and things that he says on earnings calls, telling the jury that that's for the issue of punitive damages and not for the issue of whether the system is defective. Do they actually sort of understand and pay attention to that? I really don't know. Some of it is like in a way, this case, it's not unique, but it's unusual in the fact that the victim is not the driver, right? So most of the time in the cases that I've talked about and in most of these crashes, the person who gets killed is the one who's ignoring the warnings and playing games on their phone and that kind of thing. And so I think it's very possible that if you ask a jury to just compare A and B, where A is the driver and B is Tesla, maybe they have different percentages at the end of the day versus when you introduce the C, who's just a totally innocent bystander standing on the side of the road. Now this it happens more than you think. There's a case in Texas that's pending right now where there's a group of, I think, 5 police officers who were responding to a crash and standing by the side of the highway. And this is another situation that Tesla's system does really poorly in, where there's a lane closed and you're following a car and the car in front of you pulls over to the next lane because the lane is closed, and all the Tesla sees is lane's open, traffic is gone. I can resume my desired speed. And so it accelerates right into, a fire truck, a police car. This happens a lot. So that's another situation where you have very sympathetic plaintiffs. And yes, a driver who's not paying attention, but also a defective system. I think a final thing that I wanted to say in response to your question is it raises this tricky, interesting issue in products liability law of foreseeable misuse, right? So it's true that Tesla can say that it's misuse to like turn the system on when you're on a surface street or to pull out your phone and look at a game while you're driving. And they do have instructions telling people not to do that. On the other hand, there's a long tradition of products liability law saying that it's not really up to the manufacturer to just define however they want to what counts as misuse and what counts as appropriate use. And so when you have a whole set of people who are in a very foreseeable way misusing a product in a consistent manner, then there is an obligation on the part of the manufacturer to fix that in the design process if they can do so in a way that's feasible. And so, that's an argument that worked in this case. And so I think it could work in future cases. Yeah, Travis.
Great. And so before I ask my question, I'll say that in the moment I'm going to drop the code, the CLE code in the chat for anyone who wants the CLE credit for this hour. So I want to point to Mark Mayerson's chat question, which was kind of same question I had, was about Tesla's own insurance play. I remember reading something about that like it would be very natural, it would seem, for Tesla to offer Tesla insurance. And I mean, it seems like there are some obvious, and like this is going to betray my ignorance of insurance regulation. So for the regulators in the room, forgive me, but like it seems like there's some obvious problems with that. Like one of them would be like if they want to offer below market insurance in order to juice their Tesla sales or to make basically like especially in a kind of winner take all market, like if that kind of like subsidy is not, you see that in a bunch of other markets too. But also like I would wonder if there would be sort of not less obvious benefits for Tesla controlling the insurance of the drive, the cars that go out there. So like would it give them better like more control over the settlement negotiation or the way the trial is conducted in a way that would potentially allow them to kind of limit the negative media exposure or something like that. Like there's some sort of interesting potential conflicts of interest that would arise in if they were to pursue the path of offering, like creating their own insurance company just for Tesla auto insurance. And so anyway, that's kind of off topic, but I was wondering whether you had done anything about it.
No, it's an interesting point, and thank you for bringing the chat to my attention. It's something that I meant to say in response to Dan's question, but forgot. So yes, it's true that Tesla has their own insurance company, and my sort of my suspicion is that it is mostly a marketing thing, and that they're doing it because they want to contribute to this narrative um, that the Tesla is safer when you have autopilot turned on. And that's something that they've been arguing from basically day one, where day one is the press release that they released in 2016 in response to the fatal crash of Joshua Brown. Like almost literally the next day, they posted a statement on their website saying, it's really sad that this happened, but it's actually much safer than all you terrible human drivers who do things like get drunk and fall asleep. And that, was an issue that was litigated at trial to some extent. They had a lot of arguing back and forth about, is Tesla actually safer when you turn autopilot on? And they've never really released enough data to make the data scientist types, satisfied that they agree with Tesla's claims about that. So yeah, I don't know, so the discounted insurance for people who agree to use, part of it I feel like is marketing. Another big thing that I didn't get into yet is that one of the reasons that Tesla introduced Autopilot is to help train its AI system for level 4 and 5 automation. And so, and the term they use is shadow mode. So what they say is we have our sort of like algorithm is watching your driving in shadow mode so that it can learn how to drive from observing all these millions of miles that Tesla owners are doing out in the real world. And that's a huge advantage for us competitively because unlike Waymo, we don't have to build special cars and run them in special theme parks to train an algorithm. But the unfortunate thing is what it means is we're treating all of our customers as sort of like data guinea pigs that help train our algorithm. And so I wonder if the insurance is another part of that, where it's giving people another reason to turn on, the driver assistance features in every circumstance that they can think of to funnel more data into their system and help improve it. So yeah, I don't know. Now, the regulator side, I don't know. Would people say like they're charging inadequate rates, and they're not going to be solvent? Yeah. And I mean, maybe I can blame Dan for if this is a misconception because this comes from his book, but I feel like there's no way that a regulator, like I don't solvency regulation, are they really going to say the rates are inadequate and that Tesla, one of the wealthiest companies on the planet, is facing like a solvency risk? I don't know, but yeah, it's a really interesting question. Okay, I see Aaron has put in the chat that his hand raise feature is not working, but he has a question. So
Good
Aaron.
afternoon. Thank you for sharing this with us all. I too found this to be fascinating and really interesting. So I had a thought and a question. So I know that Tesla, was, found to be guilty and they like pretty much there's going to be punitive damages in the amount of 200 million, which I know they've since appealed it and they don't agree with it. But interestingly, I do agree with it. I think it was appropriate considering that it was so easy for the driver to, I guess, circumvent that feature and, just not be engaged with driving the vehicle. It seemed like it was easy for him to do that. So I guess what were some of the things that they found in the appeal that may warrant it being overturned or even lessened, I guess?
Yeah, I think the key argument on the punitive damages point. So there's some precedent in Florida from the Florida Supreme Court that goes back quite a ways that says that to get punitive damages for a car crash in Florida, the standard is so high that it's equivalent to a criminal charge for manslaughter. And so there's language like you have to basically know that you're hurting people or something like that. So it sounds like a very high bar and like an unusually high bar. And the precedent is specifically talking about like when can a car manufacturer be liable for people dying in car crashes? And that's the argument that Tesla made in the Banner case, which was the previous crash, like literally months before this Benavides crash. And it worked in the Florida Court of Appeals. And they made that same argument to Judge Bloom in the federal court, and including at the close of trial. So after plaintiff had finished producing evidence, they moved for judgment as a matter of law on the punitive damages issue and pointed again to this Banner case. And the judge said, I'm letting the jury deal with this. So, is that going to be grounds for reversal? I don't know. We'll see. I do think like I don't have the manslaughter language right in front of me, so maybe I'm wrong about this, but I do think that there's a very disturbing pattern here on Tesla's side of like indifference to the string of crashes that they've had, all with virtually identical circumstances. And so I feel like it's at least a jury issue. And so I'm not convinced that they're going to win, but it's seemingly a strong argument. We'll see. Andrew.
I know there's an ongoing literature on this, but I'm curious if sort of like observing this trial, you have any thoughts about what we might call, I guess, kind of like the specter of conversion from tort, kind of individual tort liability to product liability. In the world where no one is driving, who's at fault for any crashes that occur. Yeah, I'm just curious if how you see that progressing.
Yeah. So there's, I think I'm going to get this right. There's a guy named Bryant Walker Smith who's written a lot in this area. And I think this is him who has this theory, what he calls the bigger slice of a smaller pie hypothesis, which is that the overall sort of pie of car accident costs will shrink as we get better and better vehicle automation and take humans out of the equation, because humans are, human error is responsible for something like 94% of car crashes. So the pie will shrink, but the car manufacturers will be left responsible for a bigger slice of that smaller pie because of what you're saying, that when you remove the human from the equation, who's to blame for a car crash is, it seems like the car manufacturer, at least in situations like this. Now, so far, Waymo is operating like a fully autonomous, no driver in the driver's seat ride sharing system in LA and many other places. And to my knowledge, they have not had any kind of serious crash so far. I know they killed a cat in San Francisco that was a beloved neighborhood cat, but I don't believe that there has been any sort of serious human injury in Waymo, and they've driven, I think, billions or maybe even trillions of miles at this point. So, it's possible that as we really get to highly automated vehicles, that there won't be any car crashes. And that's been the sort of like bull case for this from the beginning. And we'll see if we ever make it there. But I do think the dynamic that you're talking about is correct. That the less involvement and responsibility the human has, the more the costs seem to lie with the manufacturer.
Great. Well, I guess we're at the top of the hour. So thank you, Alex, for joining us, and thank you all for coming. We hope you have a great summer and look forward to seeing you again for the next edition of the Insurance Law Workshop in the fall.
And if anybody has any suggestions or wants to present, please send one of us an email. We welcome those.
Agreed.
Thank you so much, all of you. I really appreciated it.